had them fixed, and for a month, had this soft cast on it from my crotch all the way to my ankle. Kept my leg absolutely rigid until the doc gave permission to, loosen it and
Okay, yeah, just
gradually
got the, yeah, there it goes.
flex.
Okay, great, thank you.
But I couldn't wear long pants with this big cast. So I usually wore shorts. So I started a month-long arbitration hearing with Earl Lasher of Brown Brewer on a Monday morning. I asked if we could start it at 9:30 because my last visit to the orthopod was that morning at 8. He said I could for now go without my clothes. But because I had to get over there, I had my shorts on, nice, long black socks, white shirt, tie. Problem this time, and I didn't, but suit coat looked weird, so I wore a very nice fisherman sweater. And I show up for the hearing. Hi, Paul. Show up for the hearing, and Brewer says, this is a first. Paul, this is Craig.
I'll let you guys finish.
How you doing? No, we're
just treatment bowl. You realize what this today is?
Is it your birthday?
it is.
Oh, congratulations.
Thank you.
How old did you get to be today?
I am officially Social Security eligible.
Oh, okay.
I mean, I can start drawing.
That could be anything from 62 to 60.
No,
Isn't that 65 and a half?
I can start drawing my full pension.
Okay, and you should. You've earned it.
Yeah, because I may not live long enough to collect it all. So,
65?
67?
Oh, 67. Oh, okay. Yeah, so
You actually can do it at 65.
That's
If you
right.
wait to
you
67.
make a lot more money.
Yeah, a lot more. 8% more a year.
Tons of it. I'm going to be 66 in a month.
Well, there it is.
Craig, do you practice here in town?
I do. I also started here in the Grand Central Building for 25 years.
Okay.
How about you?
I'm out in Federal Way,
Okay.
and I have a satellite office in Windsor.
Oh, in Windsor, yeah. So I
Which
spend-
is where he
spend a lot of
officially
time-
resides.
I spend a lot of time over there.
Do you really?
Oh, I've been going over there since 72. A lot of the Packers.
That's before the castle.
Oh, yeah. A lot of the. Well, I was living in Spokane at the time. I was teaching at Gonzaga and going to law school. But a lot of the Packers over there are friends of mine, and I've been going up into Satan for many, many years.
Okay. I have a home in the Rhine.
Sure. Yeah.
We spend whatever time we can with them.
And my wife is a horsewoman. Hi, Scott. How are you?
Brett, how are you?
Good.
Yeah.
Good to see you.
Okay.
There today?
What's that?
Today, I saw that today.
He called me. He called me from the office over in Georgia. But basically, it was.
Hey, I'd love to go to your party. We're gonna be in Palm Springs.
Nobody asked him any questions.
But I'd love to talk to you.
They may have been called. He left. Got up at 5. Left Madison Park at 6. Arrived in Olympia at 5:7. He's always nervous about that mess on I-5 through JBLM. Right. So he sat outside in the parking lot in his car in Wall Street.
Oh, okay. I think so.
And then he came down.
She was so excited. You know,
Yeah, well, Chris is a good guy. I really like him. He and I didn't overlap much at Perkins. But I certainly remember him as a prosecutor, prosecutor's attorney. And as when for the governor story you were trying to tell. It is my silence can be bought. Listen, maybe you tell them and they let me go home and have a scotch instead of.
Tell you what happened with her. Back when she came down, she got married here.
Dave, I was just talking about Paul.
It's really interesting. No bad one. She's actually in the house.
Senator.
Oh, no, she is. What are the differences? They say that, you know,
The only difference is the clause in the House Bill, subsection 5 of section 2, which says that the court in interpreting the act reports and whatnot, and comments that were on the UN and elsewhere.
I know.
Senator Robad, who spoke a little, chairs the Senate.
Yeah, this guy.
The guy should have been a lawyer, but I'm like,
She's like this.
the reason he wouldn't do Bill here last year was he didn't have the depth of writers and he didn't like it.
Yeah.
And anything WSBA was for, I'm against. Well, and besides, Ms. Leathers, you insulted me, or you dissed me years ago, and I still remember.
Unfortunately, that's becoming mainstream politics in the United States.
So, anyway, but I think,
I'll call you back. 6.
I didn't go on the legislative website to see what they
Actually,
did.
he was a senior partner at the
Executive session. But I bet it was, and then I get this, and it goes to rule.
Beverly Hills, kind of like, not exactly Beverly Hills, but more like West LA. You know where that is? Kind of like where the Getty is? Yeah. They're like right by the Getty, and also the big house on deck.
Well,
So we're actually definitely close. I mean, I love that. Mike, right? So we're going to stay with our house. Yeah.
we, actually moved on.
He just turned 80 and it's a 23 days for us. So I think we're just going to be very,
Made nice to Senator Robad, and spoken in constitutional about development of the culinary plans, my wife.
I would expect a very good explosion.
So,
How are you? Ski season.
John, nice to see you.
Scott, nice to see you too.
Sort of track you on what you're doing. It's great.
Yeah, thank you very much. Sure. Well, it's nice to see you again. I remember when you walked into our AAA office.
I actually have one right now.
Oh, that's fantastic. Great.
Yeah, not a lot of them, but it's been
Yeah, well, try it out here.
oh, I guess
Pretty much right.
so like, what happened?
Yeah.
Are you on the?
No, I'm just default.
Okay.
Yeah. So. Gonna get started. Okay.
curtain call.
Hey, Mel. Get out of the green room.
Well, I guess we'll go ahead and get started here. Everyone, welcome. This is a WSBA membership ADR event, and we're glad to have you here on a Wednesday evening. My name is John Butler. I'm at 308 Seattle University, and oh. And that's a reminder, everyone who is speaking, please speak into the mic when you have a question. As I was saying, my name's John Butler, and I'll be moderating tonight's panel. We've got a very distinguished panel of ADR practitioners, and once I introduce them, I'll turn it over to them to introduce the topic for tonight's panel.
What?
Oh. Well, first on my right here is Craig Belles. Craig is the owner of the Belles Group and has over 40 years experience, as do all of our panel members, I believe. As an arbitrator and mediator since 1980, he has been chosen to arbitrate nearly 300 disputes, including commercial and international contracts, high-tech, IP, personal injury, insurance, healthcare, securities, employment, and construction law issues. He is a member of many panels, including the AAA, ICDR, World Intellectual Property Organization, ICC, FINRA, International Institute for Conflict Prevention and Resolution, Resolute Systems, King County Mandatory Arbitration Panel, and U.S. District Court for the Western District of Washington. He is also a member of the National Academy of Distinguished Neutrals. In 2010, he received a Fulbright scholarship from the U.S. State Department and taught comparative arbitration law as well as comparative torts in the Czech Republic. Recently, he was named a Fulbright Specialist in International ADR, and in July and August of this year, he will be traveling to the island of Mauritius and will be helping them to create a culture of ADR. And finally, he is also the chair-elect of our WSBA ADR section. The next person to my right here is Mr. Mel Simberg. Mel is a partner of Simberg, Ketter, Shepard, and Purdy, in addition to his counseling and litigation practice, in which he has also more than 40 years of experience. He has served as an arbitrator for over 25 years and a mediator for over 10 years. Mel's practice focuses on international distribution, copyright, and trademark protection, web contracts, technology, and rights licensing, as well as foreign investment. He serves on many panels as well, including ICDR, AAA Large Complex Case, IP, and Commercial Disputes panels. He also arbitrates security disputes through FINRA. Mel handles international and domain name disputes through the British Columbia International Commercial Arbitration Center and copyright download disputes through the Center for Copyright Information. And finally, but certainly not least, Mr. Phil Cutler, on the end over here, is the principal and president of Cutler, Nylander, and Heaton. With over 40 years of experience as well. Phil's practice emphasizes arbitration, mediation, and other forms of ADR, as well as litigation and counseling in business. Phil also practices in the areas of corporate and commercial law, business and government regulations, licensing, trade secret, and IP law, antitrust and trade regulation matters, as well as appellate practice. Phil frequently serves as a mediator and arbitrator on the American Arbitration Association, FINRA, as well as private panels. Since 1997, Phil has chaired the ADR Roundtable, a by invitation only association of Seattle lawyers and educators with an avid interest in mediation, arbitration, and other forms of ADR. Before I turn it over to them to introduce tonight's topic, I'd just like to let everyone know online that you're welcome to ask questions by typing into the comments box, and everyone here is welcome to ask questions throughout the presentation as well. Just raise your hand and we'll bring over a mic, and as Helen kindly reminded me, to speak directly into the mic, please.
I was going to try to pull this microphone out, but I don't think that was going to work. So anyway, we put together some handouts. You know, sitting up here, I'm thinking I'm Ellen DeGeneres or Dr. Phil or something, huh? Anyway, I don't think I've ever given a talk seated in a chair like this. Anyway, our topic tonight is avoiding litigation-style discovery and arbitration. Discovery is something that all lawyers know about, and almost all lawyers want, and almost all lawyers think they want more of. But in arbitration, the process simply doesn't work as well if we have federal court litigation discovery. lawyers need discovery for a couple of reasons. First of all, they and their clients needed to analyze the case for settlement value or for mediation, but they obviously need it for purposes of preparing for the evidentiary hearing and prosecuting or defending the case. Parties choose arbitration for a lot of different reasons, and sometimes it's chosen for them, but most often, at least insofar as we're concerned today, the two reasons that arbitration is good is its general economy and its speed, the speed with which people get a result. Those goals can't be met if we have federal court litigation style discovery. You know, the wholesale importation into an arbitration agreement or some arbitration proceeding of rules 26 through whatever 37 just doesn't, the process just doesn't work well. Another point is that in court, the general touchstone is whether a particular request or discovery vehicle that's being used will lead to the discovery of, excuse me, I've been suffering from a cold, lead to the discovery of admissible evidence. By contrast, in arbitration, the general touchstone is the evidence relevant to one of the issues, factual or legal, in the case. So the scope of appropriate discovery is generally a function of the issues, the complexity, the amount in controversy, the parties' arbitration agreement, which may or may not deal with discovery specifically. More and more lawyers tend to put in discovery restrictions in their arbitration agreement. Applicable federal, which is the Federal Arbitration Act, and state, Washington Uniform Arbitration Act, federal and state law. There are the rules under which the arbitration is being conducted, whether they're AAA or some other rules. The arbitrator's general philosophy about case management and discovery, and the degree to which the parties and their lawyers cooperate with each other and with the arbitrator in developing and implementing a discovery plan. I'd suggest that for those of you who don't know about them, you look at, and by the way, I'm simply highlighting a few points on the little outline that some of you may have gotten by email is up on the section website under events, and maybe there were some passed out today. But you might look at the College of Commercial Arbitrators protocols for expeditious, cost-effective commercial arbitration. These protocols were adopted following a 2009 summit that was convened by the CCA, the AAA, JAMS, and other providers, general counsel, private lawyers, and others, to take a look at how commercial arbitration was developing and whether we liked the way it looked. And increasingly, clients, businesses, in terms of what I do, almost all my cases are commercial cases. Businesses weren't liking the way arbitration was looking. It was taking on all the hallmarks of litigation. In any event, take a look at the protocols. The CCA has a website. It's called thecca.net, and it's in those materials. So tonight we're going to talk about some ways in which the arbitrator can manage discovery to achieve those goals of speed and economy. Craig is going to lead off and talk about arbitration clauses, some drafting tips, and arbitrator suggestions that parties might modify their arbitration agreement if that's appropriate. I'll talk about preparing for the initial preliminary hearing. And either Craig or Mel we'll jump in and talk about the hearing, that hearing itself, and then either Meg or Mel or Craig, or maybe all three of us will chime in and discuss other forms of discovery and handling discovery disputes. So, Craig? These mics are very heavy.
Thanks, Phil. Thanks, Mel, for being here. Thank all of you for being here as well. Arbitration clause is not the most stimulating title for part of a discussion, but it is kind of an interesting area, actually. As Phil indicated, we kind of start with the given that discovery can be the most expensive and time-consuming aspect of litigation, and it can also do the same thing in arbitration if the parties and the arbitrator permit it to be so. That's not to say that discovery isn't important in many cases. Some of us have sat through hearings where we've basically had a deposition done on every witness because they weren't given the opportunity to take a deposition beforehand. So they're now, for the first time, narrowing those issues. So it's a balance. The presumption, of course, is that the parties, by choosing arbitration, have chosen something different than litigation, something that's faster, more economical. And one of the very first places you start, both as an advocate and as an arbitrator, is looking at the arbitration clause. As a drafter of an arbitration clause, you want to consider many things. And we're not going to get into all of the various aspects of arbitration clauses and whatnot. As an arbitrator, you have to look at the arbitration clause for many different reasons, but primarily you look at it to determine what rules apply, whether or not there are any limitations on discovery or any guidance with regards to discovery in that context that we're talking about today. But you really look to see what rules apply, and the rules, and we don't have time, of course, to do a compendium here of all of the different discovery permitted or excluded under the various rules, but they differ rather dramatically. Under the AAA has rules that limit the amount of discovery that can be done to a certain degree. The other thing that's important, probably one of the first things I forgot to mention about the AAA rules, is that the parties, if they want to limit the procedure in an arbitration, like limiting discovery, they can do that if they put it into an arbitration agreement before the arbitrator is appointed. Rule R1A of the AAA Commercial Arbitration Rules says the parties may vary the procedure set forth in the AAA Commercial Rules. After appointment of the arbitrator, such modifications can be made only with the consent of the arbitrator. So you're going to have more effect on the procedure and the amount of discovery you get if you can put that into your arbitration clause before an arbitrator is appointed. Problem, of course, is you have no idea what your dispute's going to be like. It's very difficult beforehand to determine, do you need depositions? Do you need interrogatories? How much exchange of documents do you need? But under the AAA rules, if you want to do that, you want to do it a little bit earlier than later, before the arbitrator is appointed. Under the CPR rules, the Conflict Prevention and Resolution rules, they basically say that the tribunal can do whatever it considers appropriate with regards to discovery. That furthers the goals of making the resolution expeditious and cost effective. JAMS starts out, under JAMS rules, they start out with a presumption that you're entitled to one deposition. And if you want more, you can ask for it, but it's going to be begrudgingly given to you. JAMS has a whole list of considerations they tell the arbitrators to look at in determining the extent of the discovery. So in that setting, if you have JAMS rules applicable, you're going to want to look at the various guidelines that JAMS has set forth with regards to the kinds of things you can do, for example, in a deposition. We might talk about that a little bit later, but placing limitations on the depositions if you're going to get more than one, time limitations in terms of how long the deposition is, during what period of time you can take depositions. Little practice note, if you place time limitations on a deposition, you want to make doggone sure that people aren't permitted to make speaking objections, because all your time will get eaten up by the other side. The CPR, I said that they had indicated that you're entitled to discovery that's appropriate, considering expedition and cost effectiveness. They've also recently published a bunch of protocols with regards to both general discovery and electronic discovery. And they, in their protocols, give you a sample, a clause to put into your agreement if you want it, which addresses specifically discovery. And it says you can pick model A, B, C, or D. A being, for example, a very, very limited exchange of documentation, whereas when you move into B, C, and D, it gets progressively more liberal, but not very. Discovery is very, very limited. And if you have a CPR case, a case where the CPR is listed in your contract, if you don't list any of those particular models, A, B, C, or D, with regards to discovery, the arbitrators are instructed to limit you to A, which is basically the exchange of the documents you're going to use at the hearing, and nothing more. So that's something, there are all sorts of pitfalls to a certain degree. You've got to be familiar with the various rules, both as an arbitrator and as an advocate who's writing the agreement. I sometimes, when I write an agreement, I will identify specific rules that I like, or at the very least, because a lot of times these are negotiated and people they don't know what these various rules mean, and they don't want to agree to them. So I might just say, we're interested in discovery that's consistent with the tenets of arbitration and inconsistent, if you will, with traditional litigation. So the arbitrators are instructed clearly that the parties picked arbitration so that they would have a more expeditious and cost-effective way of dealing with these things. The thing that you run into oftentimes as an arbitrator in these matters is you have parties who either in their arbitration clause or subsequently they stipulate to you that they want to have full federal rule discovery, the whole gamut, everything that you would have in a traditional trial. And that's when you start bending, or I do, start bending arms a little bit. And it's you really sit down and you start to talk to them about, is that really necessary? Is that really in the best interest of your client? Is that really what they had in mind when they chose arbitration over litigation? And the thing that's kind of interesting in this area is the difference between your classic American arbitration and your European international arbitration. In the United States, we're sort of advocate-run in terms of the way we do trials and arbitrations. The advocates decide. If the advocates stipulate, we'll go with them. Well, that used to be the rule. It's not so much anymore in the United States. But in Europe, that was never the rule. In Europe, for the majority of international arbitrations, the arbitrators are project managers. They're the ones who decide what's going to go on in this arbitration, and not the advocates. And the fact that you've stipulated to a particular kind of discovery is not going to be controlling. Now, recently those two have moved a little closer together. In the United States, you have arbitrators who more and more are saying, hold it, under all of these rules, I have a great deal of discretion as to what I can do. And in Europe, more and more they're starting to say, well, okay, we're not going to adopt American-style discovery, but we are going to, under these circumstances, with a sufficient showing, and the showing sometimes really has to be sufficient. You have to spell out exactly what you're after, exactly why a document's relevant, exactly why a deposition is important before the tribunal will give it to you. So I'll just take a couple more seconds and I'll turn it over to Mel or to Phil. The other thing about arbitration clauses and the way they address discovery is more and more, I think people are becoming a little more sophisticated with regards to the issue of alternative dispute resolution. And when I say that, I mean the potential for mediation in a large commercial setting. I learned early on from my professors in international ADR that almost every one of them, and these are primarily practitioners as well, said if you can mediate a case in an international setting, you always want to do that over arbitrating a case. Because even though arbitration is generally faster, generally, and less expensive, generally, mediation or conciliation or early evaluation or all the other various things that are available will typically resolve a case much more expeditiously without all of the jurisdictional issues you typically run into in an international arbitration. So, as well as many, many other issues. So what you've got in international clauses as well as in domestic arbitration clauses are a suggestion sometimes that the arbitrator bifurcate the discovery to a certain degree, so that the arbitrator is instructed, look at our discovery and let's talk about what's necessary to mediate the case. What discovery is necessary to get us to mediation so we have a decent mediation? And then we can talk about the discovery that we would need for a full arbitration. Therefore, working in the whole concept of mediation. Let me think. I think that's probably the last thought that I'm going to share with you today. I should just mention that as you move through the various rules, you get into the ICDR rules, the International Center for Dispute Resolution rules, your discovery becomes a little more diminished and you have to make a greater showing for more discovery. I might just mention, even under the AAA rules, once you get over $50,000, you're into the large complex rules, the additional large complex rules, and there's a presumption of, I think it's one deposition is at the most. So there's a move generally to limit discovery in these matters. And finally, there are the International Bar Association suggested model rules. And those rules on the taking of evidence in international matters, those rules I would submit are even more limited in terms of what the starting point is for discovery. They all have a sort of a presumptive starting point, and if you're going to move off of that and ask for more discovery, you're going to have to make more of a showing in order to get it. So those are all things you want to consider in picking your rules in an arbitration setting, or as an arbitrator, making sure that you're very familiar with your rules when you're looking at discovery.
So before we leave clauses entirely, I wanted to add a couple things to what Craig said. There's a lot you can do in advance. For example, limiting the scope of the arbitration by limiting the issues. If you're a patent licensor, it makes absolute sense to say that the arbitrator does not have authority to rule that the patent is invalid. And there are good reasons to do that, and that shouldn't be objectionable to the licensee as long as the licensee can still get the relief it seeks in the arbitration. But you've taken a big issue off the table, and you're thus limiting the issues that you have to address either through discovery or another way. The second thing I wanted to say is, as Craig mentioned, and I think this is a theme that's you're going to hear several times through this presentation, is the mindset of the parties and the counsel determine a lot about what's going to happen in an arbitration. And a lot of companies and general counsel defer to their outside attorneys to draft arbitration clauses. And even in the arbitration process, they may be deferring to their counsel. And that means they're giving up control to someone who does not necessarily have an interest in an efficient, speedy, low-cost result. And I say that not just because the attorney may have a financial conflict of interest. The attorneys don't like to do things, none of us like to do things on a short deadline if we don't have to. And we have other matters that we want to pursue, so we don't want to have to round up all our horses and go full bore on something that's going to displace everything else that's on our task list. So part of it is in drafting the clause relates to the rules, but part of it also relates to what's the process of the arbitration, and that can be addressed significantly in the arbitration clause. And an arbitration clause should not just be an afterthought in an agreement, but should be thought out entirely in terms of what issues should you allow to present, what kind of discovery do you want to have, what location makes sense to keep it inexpensive. Are you going to have a three arbitrator panel or a single arbitrator panel? Do you want someone who's an expert in the subject matter or someone who is maybe an expert in the process? One more thing on mindset is that, as Craig mentioned, the mindset in European proceedings is that you prove your case from what you have. You don't prove your case from something you can find through a fishing expedition on the other side. That's just not allowed. Law schools don't teach that. Law schools do not really teach attorneys how to prove their cases. They teach them how to deal with the civil rules, and they teach them how to respond to the discovery issues that come up under the civil rules and how to comply with the civil rules. But particularly in an international setting, you're not going to prove your case through discovery. Independent investigation is the best way to prove your case internationally and in a lot of domestic cases as well. And attorneys need to have that mindset. They need to say, we talk about getting the cart before the horse. The rules are the cart. The horse is, how are you going to prove your case? You need to think about how you're going to prove your case first, and then you can determine, well, I need something from the other side, and figure out exactly what that is. And in arbitration, as we will get to, then you find out how you request that something that you can show you need from the other side. But you don't need subpoenas to talk to third parties. You don't need subpoenas to go on the internet and do an internet investigation. You don't need a subpoena to hire an investigator to go out and inspect a site, to go talk with customers, and provide other sorts of investigation that may enable you to prove your case without relying on the other party. You really put yourself at a power disadvantage if your case is dependent on what the other party is going to produce for you.
Okay, I'm going to talk to you mainly as the arbitrator, because I think a lot of you, if not most or all of you, get into arbitrations from the judge side, you know, where the judge kiss my ring sort of deal. I've conducted hundreds of initial preliminary hearings over the years. The initial prelim is the first opportunity for the arbitrator to demonstrate familiarity with the case, familiarity with arbitration practice and procedure, the rules, the differences between arbitration and judicial proceedings. It's also the first opportunity to start to guide the lawyers and their clients to handle the case in a manner that's consistent with achieving the two goals that I talked about at the beginning. speed and economy. It's tempting as an arbitrator sometimes to think of ourselves as a federal judge. We got robes and we got a lot of power, and I can dictate to you, you peon lawyers and your clients, how you're going to do things. And while that's attractive, I suppose, on an emotional level for the arbitrator, it's exactly the wrong thing to do in terms of dealing with the lawyers and their clients and your case. It's real important not to micromanage or to dictate. Rather, I tend to think that we're most successful as arbitrators when we bring the clients and their lawyers along to understand that arbitration is different from litigation. We're going to get through this a lot less expensive, a lot quicker, and gosh, your client's going to be a lot happier. Now, there's nothing to prevent the client from being unhappy or a party from being unhappy with the result. But as long as, in my experience, even when I had a case years ago where, I don't know, the award was $1 million against the respondent. We wrote a reasoned opinion or a reasoned decision. I was talking to the lawyer a couple of years after that, and I said, gee, I didn't think you'd ever talk to me again after that case. And he said, why? Because you guys ruled it against us? I said, well, that was one. And he said, oh, no. He said, I told the client his case was worth, a bucket of warm spit. He was going to lose. And he was not happy that he lost, but he felt he got a good shake. He got a fair shake. And I think it's real important for us as arbitrators to communicate that to the lawyers and their clients. Years ago, I started laying out to counsel in letter form before the initial prelim what my expectations were of them and their clients, and what I thought were their expectations of me. And you've got in the materials that you either got by email or picked up in paper form sort of the latest iteration of that. I tweak it every time I have a case a little bit. The last one that I tweaked was in November of last year. It's actually quite lengthy, but it lays out, and I accompany it with an agenda for our preliminary conference. And it lays out the topics that we're going to talk about during our conference. And one of them is discovery. And I deal with discovery, and I think it's paragraphs 6, 7, 8, and 9 in that letter. And I tell them that I'm going to give you reasonable discovery, but you've got to be able to demonstrate to me why what you want is reasonable. Somebody that comes in and wants 50 depositions without explaining why, or even if they come in and say, well, we've agreed that we each get 50 depositions. Well, I'm sorry. I'm in part a guardian of the process, and the last thing I want is for their clients at the end of it to say, God damn it, this case cost me an arm and a leg, an arm and 2 legs. And the arbitrator didn't pay any attention. He just let my lawyer do whatever he wanted to do. And I think we have to exert some measure of control. What I tell the lawyers is that they need to focus their discovery needs on what is needed to prosecute their claim or defend that claim. As I said before, the touchstone in arbitration is relevance, not will it lead to the discovery of admissible evidence. that's a standard that is carte blanche for fishing expeditions. And the criticisms of the litigation process are legion about fishing expeditions. What I think that we as arbitrators need to do is to encourage lawyer involvement in developing a plan for, in litigation parlance, we still call it discovery, and for lack of a better term, it's easier, that's what I'll refer to it here. But if you look at arbitration provider rules, they talk about information gathering. It's not discovery, it's information gathering. And for instance, well, one of the things I do is tell the lawyers that, and their clients, that within a certain period of time after our prelim, they're going to exchange all their reliance documents. And they're going to tell each other about their key witnesses. And then they can start talking about what other documents, et cetera, they need. I think it's very important, and the reason I send this letter out before the prelim is that I want to have the lawyers start talking with each other so that they come to the prelim with an understanding of what I'm looking for, what touchstone I'm going to apply, what standards I'm going to apply, but also to get them thinking with their clients about how can we get what we need, not what we want, but what we need to get this case done. And I think it's important that regardless of one arbitrator's mindset at the beginning of a case, one has to be open to modifying those views as the case unfolds. You know, it's rare that your understanding of a case is all-encompassing at the beginning. It unfolds. In any event, that's all I got to say on that. We're going to move on to, what's your next topic? Are you going to do it? Yeah.
Well, just to echo one part of what Phil was talking about is that the hearing, what takes place at the preliminary hearing is set up by what takes place in advance. And as Phil stated in his letter is excellent. I recommend everyone take a look at it. Just like a good mediator, you don't want to wait for the day of the mediation or the day of the preliminary hearing in arbitration to begin talking about what's going on. You need to set things up in advance. And particularly in arbitration, what you want to do is you want to get counsel talking with each other, and you want the parties involved so that the process can move along expeditiously and move along economically. And again, getting back to this mindset that we as an arbitrator want the attorneys to have is this is a low-cost, fast-track proceeding, and this is how you can help make it that way. And how do you get the attorneys to adapt to that mindset? Some of them are going to come along just by the suggestion. Oh, we hadn't thought about talking with each other first, before having the preliminary hearing. Sure, we'll talk about scheduling ahead of time. You want them to talk about scheduling the hearing, because the hearing on the merits, the hearing on the evidence, is the light at the end of the tunnel, and the length of that tunnel depends on where that light is located. So to the extent that you can have a hearing in 6 months instead of a year and a half, or a year instead of 2 years, you're going to speed up the entire process. And just by speeding up the process, you're going to reduce the amount of discovery-related unnecessary things that tend to take place. The second thing that you can do besides getting the attorneys involved in this overall process is to get their clients involved. So in preparation for the preliminary hearing, you want the attorneys not only to talk with themselves, but to be talking with their clients about scheduling the hearing on the merits, scheduling any discovery that's going to take place, scheduling what's going to take place in the proceeding. What do we need to do to move this along in an efficient manner so that when you get to the preliminary hearing, you can say, okay, what do we need to do first? Do we want to look at mediation? What do we need to do, as Craig pointed out, to get ready to mediate this case? What kind of information needs to be obtained, and can that be obtained simply by an information exchange? Because there will be an information exchange. You are going to exchange the information that you intend to rely on and the information that you have that's relevant to this proceeding, including the names of witnesses that you are likely to use. There will be a second step where you're going to have to make a commitment on documents and a commitment on witnesses. But the preliminary step is just exchanging the basic information so people know what we need to do without having to go through a formal proceeding. Other issues that can come up that you may want to address right away are jurisdiction. I wouldn't say often, but it is not uncommon that there is an issue related to jurisdiction over whether you should be in arbitration at all, jurisdiction over a party, whether a non-party can be brought into the arbitration process. And so these are key issues that you want to address first. And so you're going to organize and schedule things to address those issues first, and issues that may be determinative. If this case can be resolved by summary judgment, what information do you need to know to get to the point where those motions can be made? What kinds of motions are people thinking about? What kind of motions do you expect to make? What kind of motions might you make? And how do we get there so that we can spend our energy first on focusing on what's most productive? And if that resolves the case or resolves issues sufficiently so that instead of a 3-week trial, we need a 3-week hearing, we need a 3-day hearing, let's see what we can do to make it more efficient. We talked about how depositions are discouraged, interrogatories are discouraged or prevented entirely, and requests for admissions don't make sense. And we can talk about why they don't make sense in a minute. But first I want to talk about depositions, because depositions can be useful in eliminating issues from a matter or getting to an issue that could be determinative. Unfortunately, in some proceedings, like in securities cases under FINRA, depositions are so discouraged that the only basis for a deposition is if someone is unable to attend or can't be compelled to attend the hearing, or there are other compelling circumstances such as they're on their deathbed. And if those are the only two reasons that you can take a deposition, in 99% of the cases there won't be a deposition. And so we arbitrators are going to have to sit through, as Craig said, essentially a deposition at the hearing on the merits. Again, all of this relates to developing a mindset among counsel and a mindset among the parties about the process, that we're on this train that's moving along a path, that we want to move at a certain speed, and we all want to get there in a way that makes sense. The second part of getting the attorneys involved is getting more client control. And by that, I don't mean getting attorney control of the client. I mean getting the parties involved in controlling the attorneys. It's very helpful if you can have a party representative participate in a preliminary hearing telephone conference call, because it makes it much more difficult for an attorney to say, well, I can't possibly attend a hearing at this case until a year and a half from now because I have too many other matters that are on my schedule that are more important. That's not what his client is going to want to hear. And so it discourages the attorney from making this arbitration a lower priority on the attorney's schedule. Otherwise, the attorney's going to have to justify it to his own client as opposed to just stating it as a matter of fact to the arbitrator. I think that's enough about the preliminary hearing, so we can keep moving this along. We have 15 minutes.
If that.
That looks optimistic.
I was going to say.
So should we start taking questions?
Well, perhaps we should. There was one topic I thought that somebody might be interested in, and it's the whole issue of e-discovery, which, of course, is becoming more and more of a major issue in litigation and in arbitration, and methods and thoughts on how to control that. I don't know, were you going to talk about that, Phil, or you want me to make a few preliminary remarks about that?
I was
Okay.
trying to, go ahead, say.
I'll start that off. As many of you know, there are whole seminars that address this issue. They go on for hours. So much of discovery now is based on discovery that comes from people's computers and phones and laptops and iPads and whatnot. So as an arbitrator, you oftentimes have to address those issues, or you should address those issues in a preliminary hearing. Like Phil indicated, you typically would, if you're trying to limit it, you'd start with the documents that are going to be relied on in the actual substantive hearing. Then, of course, people are going to go, that's not enough, I want more, and then you move to, okay, relevant documents. Explain to us what documents are relevant. And then you've got the issue of what do you get to search? You get to search all the computers?
And let's be more specific about what the term relevant
Yes,
means.
yes.
Because some of the rules say specifically relevant to the issues in the arbitration and material to what the arbitrator has to decide. And that's what you have to explain to me. And if you can specifically identify the document, better. But if you can't specifically identify the document, you better be able to identify the specific class of documents you need and why.
And most of the administrative rules now specifically have procedures or protocols for e-discovery, and they talk about what you have to show in order to ratchet up your discovery, including the burden of proof and the kinds of what's meant by relevance. Like I said, the other issues that you would address is what sources that are you entitled to look at. Typically, you aren't going to be permitted to look at absolutely everything that some of the primary parties have touched. You'd start out again with the presumption of only being able to look at the computers that you worked on in the ordinary course of business, or if you were the Secretary of State, maybe a iPhone or. Then the
And where is the server located?
yes, where is the server located?
Which device?
That's right. Then the issue is, what is the scope of discovery once you've decided on the documents? Are you entitled to everything on that computer? Are you only permitted to search certain topic headings or subject headings? Are you able to throw in all kinds of meta tag terms that permit you to search everything that's involved in that? As you know, discovery is not arbitrators' favorite thing to be attempting to resolve when disputes arise. But this area is site. What's that? Yes, exactly. The kind of production, whether we're talking e-docs, that are electronically placed on a DVD or something, or hard copy, and then there's the whole issue of an issue that I ran into many years ago, 20-some years ago, where we were searching for destroyed docs. Are you permitted to hire a company that'll look at a hard drive that somebody's printed over and tried to get rid of a document 30 times, and you've got an expert that comes in and actually able to put the document back together again? In order to be able to do that, you're going to have to make a really strong showing, typically, in an arbitration. Just initial thoughts. Go ahead, Phil.
If you look at my standard letter on page 7, subsection D there, I talk about discovery, and I summarize, at least for an initial take on e-discovery some of my principles. And the whole idea is to squelch any wide-ranging fishing expedition. You know, for the lawyer says, I want to see the hard drive of, all these computers. And I want metadata, and I want this, and I want that. And in most cases, that's simply unnecessary. It costs an arm and a leg for people to produce it. Getting forensic experts to deal with computer drives and that's expensive too. And unless there's a real need, a lot of this stuff is simply inappropriate. And I think we, as arbitrators, we ought to keep in mind that we've got an option to do some cost shifting. And okay, if you the claimant, think that this e-discovery is so all-fired important, but the respondent has demonstrated that it's going to cost them $250,000 just to search for, not to generate copies or documents or electronic or paper, but to search for them, $250,000, well, maybe you should pay that. And then we'll reallocate it if it turns up that there's some great documents, smoking guns, etc. We'll allocate that cost in the final award. I guess my point is that e-discovery has become it's just become an ogre. It's killing people in litigation. I mean, it is just horribly expensive. And if we're faithful to our mantra that we want arbitration to be less expensive and more expeditious than traditional litigation, seems to me that we as arbitrators ought to be trying to limit the e-discovery sort of in that fashion. Mel?
Yeah, I'm going to ask you a question, Phil. So you mentioned that an arbitrator can allocate costs. What other authority does the arbitrator have over the parties to enforce what the arbitrator has ruled? What can the arbitrator do if a party is dragging their feet and not producing documents in time, not naming witnesses in time?
First off, each provider, the rules under which the arbitration is being conducted have something to say about this. The AAA rules, which are the rules that I generally operate under, give the arbitrator, I can't give you the rule number, but give the arbitrator a fair amount of authority. The arbitrator can draw adverse inferences. It's risky for the arbitrator to prevent a party from putting on evidence, but it's possible. There was a case out of Minnesota several months ago where the arbitrator, one of the parties moved the arbitrator, asked the arbitrator to find in their favor on something because the other party had lied, cheated, and stolen, and they could sort of prove that. And the arbitrator said, I'll reserve ruling on the motion. I want to go through the evidentiary hearing, and then I'll decide what the evidence really shows. I want to see the whites of their eyes, etc., etc. And at the end of that evidentiary hearing, in the final award, the arbitrator basically said, I found the witness completely incredible. I find that he lied, stole, and cheated, etc., etc., and there's a $500 million judgment against him. Yikes. So the arbitrator does have power. Now, pre-hearing, I think it's risky to do much more than, sort of slaps.
Yeah, and as you said, you can allocate costs, and you can also point out to the parties that at the end of the proceeding, the arbitrator usually has the discretion to allocate costs of the arbitration proceeding against one party or the other on a variety of bases, including whether they've been cooperative in the process or not. What an arbitrator, unlike a judge, does not have authority to do is to sanction a party with terms. We can't fine a party as such. Only by allocating costs, that's the closest power we have to the fining power. But we do have the power to exclude evidence, to conclude issues in favor of one party, and to prevent witnesses who are not timely notified to the other party and to the arbitrator. And there's case authority for that as well, if anybody needs a citation.
The only caveat that I'd say, Mel, is that the Washington Arbitration Act, which is verbatim the revised Uniform Arbitration Act, does have a specific provision about the arbitrator's authority to enter or make sanctions. There's no case law that I'm aware of that explains that. But if you look at the RUAA, the annotated version, you'll see sort of what they were thinking about.
I was going to say there are a number of rules that do use the term sanctions, but none of them specifically say that includes levying a fine of some kind or requiring something to pay somebody. So I've always interpreted sanctions to mean the kinds of relief that I just talked about. But that may be an open question.
Yeah, adverse inferences, as you indicate, exclusion of evidence. That's Rule 23, by the way, of the AAA commercial rules.
So, comments?
I-
questions? Surely somebody's been awake. Mr. Bender.
We're going to run a microphone over to you so the online audience can catch your words as well.
In forums which reject depositions generally, except in the most extreme circumstances, what's the practical effect in cases where the parties decide they should have a deposition or two just to make it easy to cut through the chafe? Is that something that's going to be rejected by the arbitrators?
You're talking about in FINRA ones?
Doesn't matter.
Well,
FINRA
that is the inherent conflict we're talking about today, between respecting the agreement of the parties and the attorneys with regards to discovery versus your, if you will, obligation to the process. And it's a balance. It's a balancing act. Generally, in the United States, in commercial arbitrations, it's a rare arbitrator who's going to say to the parties who have stipulated and agreed that they want to have, 5 full-day depositions, that they can't have them. Although we may do a lot of discussing with them, and as Phil has pointed out, it's always nice to have the client there so that they recognize what the costs are going to be.
Thank you.
Well, yeah, John, I have sat through, I don't know how many FINRA arbitrations, some weeks long, where the length of it is tedious, mainly because there haven't been any depositions. And, I would have welcomed somebody saying, gee, couldn't we take this expert's deposition and we'd forego a day and a half of testimony?
The way you asked your question, I think the answer depends on the procedures under the particular administering authority. So, for example, under the AAA commercial rules, there's a preliminary hearing at which discovery is discussed and measures set. Under FINRA, the same kind of thing doesn't happen. There's a FINRA rule that discourages depositions, except under the circumstances I mentioned. But if the parties both want to have a deposition and they agree on it, then it's probably never going to come before the arbitration panel, and they'll get away with it. If you call that getting away with it, we would say thank you. But
Peter.
Well, quick, it wasn't my idea, but in one case, the parties came in, they wanted 10 depositions, and I said, who are they? And we talked, and I said, do 3 and come back to me. And they did 3 and came back to me, and then they each did 1 more, and it worked out. Mel, you mentioned excluding patent validity from an arbitration. That intrigued me for a couple of reasons. First, presumably, if you exclude it, it could be litigated. So would you run the risk of parallel litigation with the arbitration? Of course, in that case also, validity in an arbitration is much different than a decision in a court. So I wonder if you could expand on that a little bit.
sure, and actually, it isn't in the sense that there's an obligation of the patent holder to report it to the patent office if there's a finding by an arbitrator or a court that the patent is invalid. So in the patent circumstances, a smart patent holder or his attorney, the patent holder's attorney, will provide in the arbitration clause that the arbitrator does not have authority to make that kind of a ruling. The arbitrator can still rule that the patent may not be enforced against this particular licensee without ruling the patent invalid.
Thank you for your wisdom this evening. As you work with the attorneys and the parties during the preliminary meeting and ahead of the preliminary meeting to limit scope and set ground rules, I imagine you get some attorneys and parties that are really cooperative and others that push back and might be a bit more ornery to corral. How do you protect your neutrality or the appearance of neutrality when you find different levels of cooperation among the parties that are involved?
Well, you're always going to run into attorneys in hearings that sometimes rub you the wrong way, be it in the preliminary scheduling hearing or the hearing itself. I've heard advocates during both types of hearings say the most incredible things, and I wanted to say, well, actually, I didn't want to. I did say. I said, you do remember who's deciding this case, don't you? Try to, gently tell the individual, and you just do your doggondest to focus on the evidence and the witnesses that come before you. At the early stages, most of us have been litigators as well as arbitrators and mediators, and we have a lot of experience with the heat of the situation, and we just try to bust through that crud and get to what the facts are. There's not much more. I mean, you can rein people in when they get out of control or whatnot, but there's all sorts of little techniques. So I thought one of the things I thought you were going to say was not only you don't only get pushback, you also get people that, for example, at the preliminary hearings that have no authority. They send in a junior, associate who is handling the preliminary hearing, and you're thinking, we've got major decisions that have to be made here today, and and these people don't have authority that in the hearing, and so you're very disappointed. Let's put it that way, and you try not to get too upset.
Well, I have never had that particular experience, but if I did, the first thing I do would be to adjourn it, take a recess, and we're going to reconvene. I'm sorry, but I'm not going to waste my time. If we can't get a hearing date set, if we can't make some progress on all of the issues that need to be talked about, you want a reasoned decision, I mean, come on. There are a whole lot of decisions that have to be made at the start. I mean, think of if you show up at a judge's pretrial conference with no authority and no idea about what's going on, you're going to be out of that courtroom real fast. So I guess we as arbitrators don't have to take it personally, and we don't have to be mean, or venal, but I wouldn't hesitate to say, stop, we'll come back. You get prepared, and then we'll talk.
I think in relation to your question, it is important that an arbitrator not only be neutral, but maintain the appearance of neutrality. And there are definitely things you can and should do and should not do in order to emphasize that appearance of neutrality. So for example, if someone makes a motion and you just realize it's going nowhere, it's the stupidest thing I've ever heard, you still restrain yourself from responding to that motion and making a decision. Give the other side an opportunity to respond, and then you make your decision based on the two arguments, even if it would have been exactly the same decision if you'd heard nothing from the second side. Secondly, we need to talk about process, not about people. And if you're getting the kind of pushback that you're talking about, it's important to bring the conversation back to the process. This is what we need to do. This is how we're going to get there. And as Phil said, if people just haven't done what you've asked them to do before the preliminary hearing, so you're there spinning wheels and wasting your time, there's no point in sitting there spinning wheels wasting time. And you say that. We're obviously not ready to make these decisions on scheduling, so we're going to have to reconvene and make those decisions. Now, how much time do you need? Because we're never going to continue something indefinitely. We're always going to be continuing it to a date certain. So can we come back in 1 week? Will everybody be prepared? Will you have talked to your clients, your expert witnesses, the key witnesses, and you checked your own schedules? Will we be able to set a preliminary hearing if we meet back in a week? Well, if you're still getting pushback, it better be good reasoning, or you're going to say, well, you're going to have to be ready in a week. We're going to set the evidentiary hearing a week from today when we meet again. So when can you meet next week? Let's get schedules straightened out.
I think that's just about out of time, although maybe some of our panelists would be nice enough to stick around for questions afterwards if they have time. Thank you all very much for coming to this WSBA ADR section panel. We'd like to remind you that the ABA DR conference is going to be in Seattle on April 15th to the 18th, and registration is open right now. Thank you all again for coming.
Yes. What's this?
These are small tokens from membership.
Hey, I'll go home and have this.
Does that go with Scotch?
I think it does, actually. It goes with Scotch and bourbon.
Scotch and some popcorn.